county parcenary and company parcenary property. What is coparcenary? The term coparcenary is derived from the Latin word parens, meaning parent, and co, meaning together. A coparcenary is a slightly narrower body within a Hindu joint family. Half, consisting of a common male ancestor and his lineal male descendants. Sons, grandsons, great-grandsons, up to 4 generations, all having birthright in ancestral property. Under the Mitakshara school, a coparcener acquires an interest by birth in the coparcenary property, i.e., he becomes a co-owner from the moment of birth, not on the father's death. After the Hindu Succession Amendment Act 2005, daughters of coparceners are also coparceners by birth with equal rights as sons. Subject to certain conditions. The concept of coparcenary is unique to the Mitakshara school of Hindu law. The Dayabhaga school does not recognize a right by birth. Instead, inheritance opens only upon the death of the father. Case: State of Maharashtra v. Narayan Rao Sham Rao Deshmukh. Right pointing arrow. Coparcenary is a subset of the joint family. Crucial distinction: Joint Hindu family, JHF. A wider concept. It includes the coparceners plus female members, wives, widows, unmarried daughters. A JHF can exist even without property. Coparcenary, a narrower concept. It consists only of those who have a birthright in the property. A coparcenary cannot exist without coparcenary property. Who are coparceners? A. Traditional, pre-2005 rule. Historically, a coparcenary consisted strictly of male descendants of a common ancestor. Up to 4 generations in the male line of descent. Generation 1, the common ancestor. Great-grandfather. Generation 2, sons. Grandfather and his brothers. Generation 3, grandsons. Father and his cousins. Generation 4, great-grandsons. Self and second cousins. Beyond the 4th generation, the descendants broke off into a new, separate coparcenary. Females were strictly excluded from being coparceners. They were merely members, with a right to maintenance and a share at partition, but not a right by birth. B. Modern, post-2005 rule. The 2005 amendment. Son, grandson, great-grandson, daughter. After 2005 amendment. Case: Vinita Sharma v. Rakesh Sharma. Daughters have equal rights by birth. They have right by birth, right to demand partition, right to joint possession. The Hindu Succession Amendment Act 2005 brought a revolutionary change by omitting Section 6 of the original Hindu Succession Act 1956 and introducing a new Section 6. Inclusion of daughters. A daughter of a coparcener is now a coparcener by birth in her own right. In the same manner as a son. Equal rights. She has the same rights and liabilities in the coparcenary property as a son. Retrospective effect. The Supreme Court in the landmark case of Vinita Sharma v. Rakesh Sharma, 2020, held that this right applies retrospectively. It does not matter if the daughter was born before 2005, or if her father died before 2005, as long as the father was alive at the time of the amendment, or the partition hasn't happened. She gets coparcenary rights. Note: a married daughter remains a coparcener even after marriage. However, a female cannot be a coparcener in her husband's family. She is a member there. Key characteristics. Creation by law. It cannot be created by contract or marriage. You are either born into it or adopted into it. Managed by Carter. The Carter is the head and senior most coparcener of a Hindu joint family who manages the joint. business and joint family property. His position is based on status and not contract, and he exercises wide powers of management. Traditionally, the Carter was the senior most male member, but after the Hindu Succession Amendment Act 2005, daughters have become co-parceners by birth. As a result, courts have recognized that a female member, including the eldest daughter, can act as Carter. Key case: Sajata Sharma v. Manu Gupta held that the eldest daughter can be Carter if she is the senior most co-parcener. Narrower than joint family. A co-parcenary is a slightly narrower body within a Hindu joint family. Half, consisting of a common male ancestor and his lineal male descendants. Sons, grandsons, great-grandsons, up to 4 generations, all having birthright in ancestral property. The 4-generation rule. Historically, it was limited to 4 generations, including the oldest member. Joint possession and ownership. Every co-parcener has an equal right to possess and enjoy the entire property. No one has a specific, fixed share till partition. Right arises by birth. A co-parcener acquires a right in the property by birth. Fluctuating interest. Till partition. Every co-parcener has an undivided interest in the whole property. Share increases by birth and decreases by death. They become definite only on partition. Right to demand partition. Any co-parcener can demand partition of co-parcenary property, converting undivided joint interest into separate, definite shares. The doctrine of survivorship. Earlier, property passed by survivorship, now modified by Hindu Succession Act 1956 and 2005 Amendment. More emphasis on inheritance rights, especially for women. Traditional Mitakshara law followed the rule of survivorship. When a co-parcener dies, his interest does not go to his heirs via a will or succession. Instead, it is distributed among the surviving co-parceners. Note: the 2005 amendment has largely superseded this. Now, even co-parcenary property devolves via testamentary or intestate succession under Section 6 of HSA, though the notional partition remains a tool for calculation. The 2005 amendment, following the Hindu Succession Amendment Act 2005, daughters are now co-parceners by birth, possessing the same rights and liabilities as sons. Co-parcenary property. This is the pool of assets held by the co-parceners. It is also known as ancestral property. Co-parcenary property, also called ancestral property, means property inherited from father, grandfather, or great-grandfather in 3 successive generations in the male line, and held jointly by co-parceners. Types of co-parcenary property. A. Ancestral property, inherited from father, grandfather, great-grandfather. B. Joint family property, acquired with joint family funds. C. Blended property, self-acquired property voluntarily thrown into common stock. Sources of co-parcenary property. Ancestral property, property inherited from a paternal ancestor. Father, grandfather, great-grandfather. Accretions, any income, profit, or rent earned from ancestral property. Property acquired with joint funds. If the family buys a new house using money from the ancestral business, that house becomes co-parcenary property. Doctrine of blending. If a member voluntarily throws their separate property into the common stock with the intention of abandoning their separate claim, it becomes joint. Essential characteristics. Ancestral in nature. It must be inherited from a male ancestor, father, grandfather or great-grandfather, not self-acquired. not self-acquired. Self-acquired property does not become coparcenary property unless thrown into common stock or treated as such by the owner. Joint possession and enjoyment. All coparceners have joint rights of possession, use, and enjoyment till partition. What is not coparcenary property? Self-acquired property. Property bought by a coparcener out of his own personal income, savings, or exertions. The burden of proof lies on the person claiming it is self-acquired. Property inherited from persons other than the direct male lineage, e.g., property inherited from a maternal uncle, mother, or brother. This is the separate property of the inheritor, though it may become joint family property if thrown into the common pool. Property obtained by gift or will, unless the gift, will specifically states it is for the joint family. Property received by an individual coparcener via gift or will is his self-acquired property. Essential concepts. A. Community of interest and unity of possession. No individual coparcener can point to a specific chair or a specific acre of land and say, "This is 100% mine." Ownership belongs to the entire body of coparceners. Their interest is only crystallized during a partition. B. Doctrine of survivorship. Before 2005, state amendments. When a coparcener died, his share did not go to his heirs, like a wife or daughter. It was distributed among the surviving coparceners. This increased the share of the remaining members. Current status. With the 2005 amendment and the application of Section 6 of the Hindu Succession Act, testamentary or intestate succession has largely replaced the pure rule of survivorship. C. Right to maintenance. Members of the joint family who are not coparceners, e.g., wives, unmarried daughters, or disqualified heirs, have a right to be maintained out of the coparcenary property. D. The concept of notional partition. Section 6 of HSA, 1956. This is a vital statutory fiction introduced by the 1956 Act to protect the interests of female members. What is it? When a male coparcener dies intestate, without a will, after the commencement of the HSA, 1956, the law assumes fictions that a notional partition of the coparcenary property took place immediately before his death. Why was it needed? Previously, because of the doctrine of survivorship. If a male coparcener died, his widow and daughters got nothing. The property went to the surviving male coparceners. To prevent this injustice, the law says, treat it as if he separated from the family a second before death. Effect of notional partition. The deceased coparcener is given a share equal to what he would have gotten in an actual partition. The widow gets a share. His widows are entitled to a share equal to that of a son out of the deceased's notional share. This notional share is then divided among his legal heirs, widow, sons, daughters, according to the rules of succession in Schedule 1 of the HSA. Limitation. Notional partition only applies if an actual partition has not already taken place among coparceners before the death of the male. Powers of coparceners. Rights of a coparcener in coparcenary property. Undivided interest by birth. Coparcener has right in the whole property, not in any specific part. Right to partition. Any adult coparcener can demand a partition at any time. Right to restrain, challenge alienation. If the carter sells property without a valid reason. Legal necessity. A coparcener can challenge it in court. Right to joint possession. No coparcener can be excluded from the family house or property, even if out of physical possession. The coparcener can claim joint enjoyment. Right to maintenance. Entitled to maintenance from the family estate. Right to share in accretions. Property acquired out of joint family funds or thrown into common stock also becomes coparcenary. Property. Sunil Kumar V. Ram Prakash, coparcenor can transfer his undivided interest. Difference between joint family and coparcenary. Joint Hindu family is the wider social unit, including wives, unmarried daughters, widows, etc. Coparcenary is the narrower legal group of those who have birthright in ancestral property. Sons, great-grandsons, now also daughters. Conclusion. Coparcenary is the core concept of Mitakshara law, representing persons with birthrights, while coparcenary property is the joint property they own. Modern law has expanded this institution by granting equal rights to daughters, making it more inclusive. Under Hindu law, a coparcenary is a subunit of the Hindu undivided family, consisting of a common male ancestor and his lineal male descendants, sons, grandsons, great-grandsons, up to 4 generations, all having birthright in ancestral property. Daughters now also coparceners by the 2005 amendment. Coparcenary property, ancestral property, is property inherited from father, grandfather, or great-grandfather, held jointly by coparceners, with unity of ownership in fluctuating shares till partition. Key features include joint ownership, joint possession, right to demand partition, and survivorship, supplemented by statutory devolution. Thus, coparcenary forms the core legal structure of the Mitakshara joint family, distinguishing it from the broader joint family membership.